Does it? Yes. Oh, yeah, I forgot you're in the... Okay. Thank you very much for having me. I'm Laura. I'm from the School of Law, and my research area primarily focuses on social media. And in particular, one area of significant interest is the use of the criminal law to tackle the harms that we associate with social media usage. Many of those harms are heavily talked about in the media. I'd probably argue that there's barely a day that goes by where the media isn't picking up on a story showcasing that negative side of social media. So my research today, as I said, is primarily focused on the criminal law, but there are other things that I've got ongoing that might be of some interest. So I am looking at doing a future project looking at online harms and young people. So we do see a lot of rhetoric about we need to protect the children online, and that is very much the focus of the online safety bill that's currently making its way through Parliament. Other things that I'm interested in is the language that we use to criminalise this type of behaviour online, and in particular the broad language, and how that could actually pose further threats to freedom of expression rather than protecting people. So just to give you a bit of a background with regards to the criminal law. So in England and Wales, there is no specific Act of Parliament that governs our behaviour online. And what we've seen is actually a mixed bag of different pieces of legislation used to govern our behaviour. And a lot of these actually predate the digital age. So the most commonly used ones for what I would refer to as miscellaneous offences. So they are the offences that don't fit well within something else. So like if it was harassment or stalking, that would primarily fall within the Protection from Harassment Act. Or if it is image-based abuse, that would fall within the Criminal Justice and Courts Act. Whereas those sort of behaviours that don't fit primarily that well into other acts of legislation will fall within what we call communication offences. And the two communication offences that we currently have in play are the Malicious Communications Act 1988 and the Communications Act 2003, in particular, Section 127. So we might already sort of see a flaw within these acts of legislation in that they actually predate most of the social media platforms that we know today. But these acts continue to be used, and they have come under heavy criticism. So if we take a sort of brief look at these acts of Parliament, the Malicious Communications Act prohibits sending to another a letter, electronic communication, or an article of any description which conveys a message which is indecent or grossly offensive, a threat, information which is false and known and believed to be false by the sender. Section 127(1) and 2 of the Communications Act prohibits the sending of content by means of a public electronic communications network that is grossly offensive or of an indecent, obscene, or menacing character, and B, prohibits false communications. So we can see that they're very similar acts of Parliament. And we might say, well, what does that matter? Well, one of the biggest differences between the two is the Malicious Communications Act is what we call an either way offence. So if you're prosecuted under that Act of Parliament, you could face up to 2 years imprisonment. Whereas if you're prosecuted under the Communications Act, that is a summary only offence in which the maximum custodial sentence is 6 months. So there's clearly a massive difference in terms of punishment. But there is actually differences between the two, but they're not easily identifiable. And that's some of the issues that we've come across in the criminal justice system, in that as recent as, I believe the last case that was picked up was around about 2019, where a mistake was made and an individual was prosecuted under the wrong Act of Parliament. So the Malicious Communications Act covers all communications, including letters. The Communications Act only covers electronic communications. But what has been supported in the case law is the phrasing to send to another, which is in the Malicious Communications Act, but not in the Communications Act. And what has been supported in that phrase is that actually the Malicious Communications Act should only be used to cover private communications, so communications between one individual to another, whereas the Communications Act will cover all forms of electronic communications. But we have seen the Malicious Communications Act being used incorrectly. So in particular, we've seen it used to prosecute individuals for comments they've made on blogs, which arguably isn't sending to another, that's a public communication. So we saw that following a blog being posted around Britain's Got Talent a number of years ago, where someone made a comment about how contestants had been groomed by organisers to participate in the show, which was proven to be false, and they were prosecuted under the Malicious Communications Act, which was the wrong Act of Parliament. So not only is there an issue with sort of the interchangeable nature of the two provisions, one of the biggest concerns with these two provisions is the language used. So we can see that we can be prosecuted for what might be deemed grossly offensive or menacing. Now, neither of them have any specific definition in law. So grossly offensive, in the case of Collins, has been defined as it will take its ordinary English meaning, whatever that might be. And that obviously renders issues when it comes to the online world, where context might be lost. What I might find grossly offensive, another may not. We know that human rights law, so under the Handyside case, we have the right to be offensive. That is part of our right to freedom of expression. We cannot, however, be grossly offensive. That is against the law, but where do we sort of draw that line? And some of these issues have started to emerge within the case law. So one of the most famous cases in relation to menacing communications is the case of Chambers, which is commonly referred to as the Twitter joke trial. I should have said at the beginning there might be some bad language, just in case there is some children in the background online. So Chambers is a very famous case. It was known as the Twitter joke trial at the time in which it was going before the courts. So Paul Chambers was due to fly to Northern Ireland in January 2010 to meet a girl that he'd met online. We had a bout of bad weather, and we all know what happens in the UK when we get bad weather. Public transport grinds to a halt, and this is exactly what happened here. So it became apparent that Robin Hood Airport in Doncaster was not going to have anyone flying out. And Chambers, in a vent of frustration, once upon a time we would have probably vented to our dog or to a family member, now we can do it online, made the following comment. Crap, Robin Hood Airport is closed, you've got a week and a bit to get your shit together, otherwise I'm blowing the airport sky high. He made that tweet, didn't have very many followers, made its way into the Twitter realm. What happened next then is a series of events. So a few days later, so it wasn't on the same day, this tweet came to the attention of airport officials. And it made its way to airport officials, and very quickly it was seen as a non-threat, okay? No one thought it was a threat of terrorism, because if it had been a threat of terrorism, we'd have gone to the Ministry of Defence straight away. But everyone sort of sat there like, well, what do we do with this? We have to do something. And it slowly makes its way up the hierarchy. And then someone makes the decision that they will inform the police. The police are informed, Paul Chambers is arrested, and then later convicted for sending a menacing message. So he was given a 12-week custodial sentence. That was at the Magistrates' Court. That was upheld in the Crown Court. At the time, the case started to catch the attention of the public, and in particular, several comedians, including Stephen Fry, whose arguments were, well, if I said this on the stage, I wouldn't be put before a court, so why should Twitter be any different? It eventually makes its way to the High Court, where the case was heard twice. In the first case, the judges couldn't come to a decision. They didn't know whether this was illegal or not. In the second case, they quashed his conviction. And it's been argued that this was a victory of common sense, with the court noting that Statistical, rude comment, the expression of unpopular or unfashionable opinion about serious or trivial matters, banter or humour, even if distasteful to some or painful to those subjected to it, should and no doubt will continue at their customary level, quite undiminished by this legislation. So the court was saying here, no, there wasn't a criminal offence. He shouldn't have been prosecuted. We've overreacted. This falls within our right to freedom of expression. But that has continued to cause some issues, particularly if we turn to look at grossly offensive. So I'm going to show you two cases. Now, I'm not saying in one of the cases that this person shouldn't have been prosecuted. I'm just saying if you look at two cases side by side, where you're trying to draw the line, it's difficult to sort of distinguish. So the first case is that of Matthew Woods from the Chorley area. So back in 2012, some of us might remember that a young girl, April Jones, went missing in Wales. The case obviously caught the attention of the press and it was actively shared on social media. So the evening in which she went missing, Matthew Woods, taking jokes from Wikipedia, posted on Facebook a number of comments about the missing school child. So he stated, "I woke up this morning in the back of a transit van with two beautiful little girls. I found April in a hopeless place. Who in their right mind would abduct a ginger kid? I love April Jones. Could have just started the greatest Facebook argument ever. April Fools, who wants Maddie?" He then went on to make comments about Madeleine McCann, who was a child that went missing in Portugal in 2007. He also then went on to make sexually explicit comments about the two school children. His address was actually leaked online, and the next day, a number of people descended upon his home, and he was originally arrested for his own safety, and then later rearrested and convicted under the Communications Act, Section 127, for 12 weeks for posting what was deemed a grossly offensive message. Okay? Compare that then to the case of Daniel Thomas. So every time I look at this case, I keep thinking I need to check if he still is a footballer. But at the time, Daniel Thomas was a footballer. And this was around about the 2012 London Olympics, where Tom Daley and Peter Waterfield had come forth. And during this event, Daniel Thomas posted the following: "If there's any consultation for finishing fourth, at least Daley and Waterfield can go bum each other, #Team HIV. Now, this was posted. It didn't get very much traction. It was reported to the police. Tom Daley didn't know anything about it until the police turned up on his doorstep to talk to him about the message. So it was referred to the CPS for them to make a decision on whether we should make a referral for prosecution. And the CPS decided no. So they stated, "There is no doubt that the message posted by Mr. Thomas was offensive and would be regarded as such by reasonable members of society. But the question for the CPS is not whether it is offensive, but whether it's so grossly offensive that the criminal charges should be brought. The distinction is an important one and not easily made." So what I find particularly interesting about these two cases, I think it demonstrates this idea of grossly offensive really well. So whenever I talk about these two cases, there are individuals who go, "I can't understand why Daniel Thomas wasn't prosecuted for that. I think that's offensive. It's homophobic at the very least. There should have been criminal prosecutions." The majority of people I speak to agree that Matthew Woods should have been prosecuted and agree with the decisions of the court there. So we can see that there is a line between the two, but where that line lies isn't easily identifiable, which obviously causes problems for members of society in that they might not necessarily know if they're going to post something, whether they could end up in court. Also leaves issues with regards to policing and the discretionary nature of this, because you might go to one police force and they might say, yes, this is a criminal offence. You might go to another and they might say, actually, no, this has nothing to do with us. And that's what we were seeing quite early between 2010 and 2013. So following these cases and chambers, the CPS decided that they needed to create prosecution guidelines. And the idea was to try and bring some clarity to this area of the law so that everyone was equal. The guidelines were created in 2013 updated 2016, updated in 2018, and most recently updated in January 2023. So the idea was to create some form of consistency within the law and to hopefully try and tackle the issue of how we apply the criminal law to online behaviour. But this didn't necessarily work. And we've seen a number of issues even since their creation. So the case of Alison Shabbat is quite a prime example of this. So Shabbat defines herself as a Holocaust revolutionist. She doesn't believe the Holocaust ever existed. And to display her opinion, her Holocaust denial, she wrote a number of songs which were set to the beat of traditional Jewish music, which contained a lot of anti-Semitic hate within them. These songs were published on YouTube. Campaign Against Anti-Semitism, which is a non-profit organisation, approached the police to report these videos. And it became quite apparent that the police weren't necessarily going to do anything. So under the Communications Act, when a behaviour is notified to the police have 6 months to make the decision. The idea is you can't have the law hanging over you forever. So this 6-month limitation period was coming to an end, and Campaign Against Anti-Semitism realised that they weren't going to get their way here. So they decided to bring what we call a private criminal law prosecution. You can do that. It's very rare, and they decided to do that. What then becomes quite interesting about the case is Shabbat's lawyers approached the CPS to try and get the case thrown out. And it's at this point the CPS said, we weren't aware of this. No one's brought this to our attention. And the CPS actually took over the case. And it resulted in a successful conviction. She has appealed it to the Crown Court. It was rejected. There was an appeal to the High Court. Her argument was that the videos were sent via a hyperlink and the law didn't apply to hyperlinks. The High Court said, no, that's incorrect. Hyperlinks do apply. So even with these prosecuting guidelines, if it hadn't have been for the actions of Campaign Against Anti-Semitism, who, yes, are a private organisation, but had some money behind them to bring the case to court, that would never have resulted in any conviction. We've also seen the case there of John Purley. That's an example of the Malicious Communications Act being used for a blog, which was incorrectly used. A recent case, again, 2020, this is quite an interesting case, and it's around comments made around transgender rights. And the court in this case actually went as far as to state that free speech encompasses the right to offend and indeed to abuse another. So you've got a significant court there saying that our right to freedom of expression actually extends to abuse, which obviously goes against the rhetoric of everything that we see in the media and the government's current approach with the online safety bill. And another case that I find really interesting, so this is an unreported case, and this was picked up by the Law Commission, who did a scoping report into communication offences. And they found that in one police force, what had happened is an individual had come in to give a witness statement and was left in the police waiting room, and he was left there for a while and he got a little bit annoyed. So he took a picture of 2 police officers in that waiting room and then edited those pictures to include genitalia on their head and posted it on Snapchat. He was given a caution for that behaviour, with the Law Commission noting that's kind of an abuse of the law there. Yes, it wasn't what he should have done, but the law isn't there to punish stupid behaviour. The law is there to punish criminal behaviour. So the issues that have emerged in recent years are the interchangeable nature of the law, so the Malicious Communications Act and the Communications Act being used interchangeably, the subjective nature of it, so what I find grossly offensive, you might not. The ad hoc nature, we don't necessarily know whether a case is going to make it to court, we don't know what the decision is going to be. This idea that it's not publicly accessible. So we are supposed to live in a world under the rule of law where the law should be publicly accessible with the help of the courts or legal system if we need it, so that we can govern our behaviour. So the law is action guiding. that's not necessarily the case with these communication offences, and we've seen that it is somewhat contradictory. So this led to the communication law reform. So the Law Commission in 2018 did a scoping report looking at communication offences. And they are very critical of the Malicious Communications Act and the Communications Act, and go as far as to argue actually they're not fit for the digital age and that we need to do something about this. So they held a consultation. A lot of people supported the idea that we do need to relook at the Communications Act and the Malicious Communications Act. And then in 2021, they made a number of recommendations. And one of those recommendations was to repeal both those provisions and to create new criminal offences to tackle these issues. So they proposed, one of the new offences that they proposed was a harms-based offence. So a person commits an offence if the person sends a message. At the time of sending the message, there was a real or substantial risk that it would cause harm to a likely audience, and the person intended to cause harm to a likely audience, and the person has no reasonable excuse for sending the message. That was initially accepted by the government. So in the Online Safety Bill, they initially, in Part 10 of the bill, proposed that the Communications Act Section 127 and the Malicious Communications Act would be repealed and would be replaced by this new harms offence. That caused some concerns to be raised around the right to freedom of expression. And I'm very critical of the Communications Act and the Malicious Communications Act, but I don't think the Law Commission's proposal would have actually tackled the issue. So they were basing it around this idea of harm. And we know in the criminal law that harm, again, is very subjective, particularly when it comes to speech. So they were defining harm as something likely to cause distress that was sent to a likely audience. That could be anyone in the world. And it was sent without reasonable excuse. So the argument they gave was that if you sent a message on Facebook, for example, telling someone their grandma had died, that would have caused harm, but that would have been sent with reasonable excuse. But this particular offence was so wide that there were concerns around the right to freedom of expression. So things around abortion rights, for example, you could argue that that could cause distress to both sides of the debate. Whether you could argue that it was part of legitimate public debate, whether that would be reasonable excuse, we didn't know. The likelihood is it would, but then at what point does it become political debate, or what point does it become abuse? Again, around the rights, transgender rights was another prime example that was raised, that on both sides of the debate you could find people being prosecuted. So this eventually led the government earlier this year to actually remove it from the Online Safety Bill. They decided that they were going to remove this harms-based offence alongside some other provisions around this idea of harm. The cynic in me says that they've done that because they want to push the Online Safety Bill through, and they were never going to do that with such vague terminology. So as it currently stands, the Malicious Communications Act and the Communications Act will remain as law. The government say that it's doing its job. The Law Commission has said otherwise. Since then, we've had a number of other communication criminal offences substituted into the into the Online Safety Bill. So two of them are the false communications, the other's threatening communications, which I'm not going to go into, but I'll just leave to one side. But the one that's most recently been substituted into the bill, i.e. in the last couple of months, is this idea of prohibiting behaviour that assists or encourages self-harm. Now, I'm going to be honest, I'm kind of not pleased with this provision. And I'm going to explain it, and I know it causes a bit of debate amongst people. We are obviously aware that this material exists online, and Molly Russell and her parents, we know, are very much pushing for this change in law. But if you look at the Molly Russell case and you look at the coroner's judgment, that was very much aimed at social media companies themselves. And arguably, we could say that it was the algorithms that were at fault here, as opposed to individuals. Whereas what this proposed offence is going to do, it's going to criminalise individuals as opposed to social media platforms. So here, D does a relevant act capable of encouraging or assisting the serious self-harm of another person, and D's act was intended to encourage or assist the serious harm of another person. So serious harm is given the definition of GBH. GBH is defined as serious harm. So that would extend beyond what we would traditionally consider to be self-harm. It could include things like encouraging distorted eating, for example. So what you have here is, if you went into Waterstones today, you could find a realm of books telling you about different types of eating, fasting, the 500 calorie diet for the day, those sort of things, which technically could be distorted eating. But if you did that online, or you had a influencer showcasing this new diet that we could argue could cause serious harm, could that then be a criminal offence? There are a lot of the Samaritans are very much for this provision. There are other smaller charities that focus primarily on self-harm who are against it. And their argument, again, is that you are going to be criminalising the vulnerable. And actually, it's very hard to distinguish between content which maliciously encourages someone to self-harm and content where we accept that people do self-harm and we help them self-harm safely, as opposed to just leaving them to it. I think it's a tricky area to sort of go down, and I think my main concern is we are going to end up criminalising the vulnerable, and that we have come a long way in our discussions around mental health. Are we now going to be taking a step back? And like I said, here, the issue has always been algorithms. I have no doubt that there will be people out there that do this for whatever reason, but they are not very many of them. This is the algorithms that are pushing it. And we've seen that in some of the research that's recently been released. So there was some recent research looking at online abuse by the Alan Turing Institute, and they found that it was 0.001% of abuse actually online. That's what existed. But because of the algorithms, we see it more. So we see it more than what actually exists. And that we are slowly going down the modern moral panic of today, worrying about the online world. So we're not necessarily tackling the root cause of the issue. I have concerns about using the criminal law. So we know that the criminal justice system is struggling. We know that cases are currently being scheduled for 2027, because that's the way our criminal justice system is falling at the moment. Do we actually have the resources to be able to pursue this? Many of the behaviours that we're concerned about are not actually new. Abuse has always existed. Fake news has always existed. The media has always distributed fake news. Our politicians arguably distribute fake news. We seem to be pushing this idea of deterrence. If we push the criminal law, that will tackle the problems, and then we'll all live happily ever after. But we know deterrence theory doesn't work, and a prime example of that is drugs. As I said, many of these issues that we're talking about are inherent within society, and actually the criminal law might not necessarily be the answer. And I'm always pushing that we need better education, that we need to be actually having some of these conversations that might seem difficult, because it's only through having conversations that you can enact change. And criminalising freedom of expression isn't going to help with that. You're never going to solve issues if we go, no, we're just not going to talk about that. We have to have difficult conversations. And I'm just going to finish up by just briefly mentioning, because I know a little bit over time, some research commissioned by Ofcom recently. So Ofcom, as the communications regulator, does research every year. And in the last couple of years, they've been doing research around young people's perception of the online world. If you look at that research, those young people are actually very positive about the online world, contrary to what we believe. They talk about how it brings them together. They acknowledge there's a darker side, but actually they prefer the online world. They actually talk about, surprisingly, how it's good for their mental health as opposed to being against their mental health, because it allows a collectiveness group to work together, and that they can support each other. And they very much are positive about it. Whereas what we'd be led to believe by the media and the government is that actually there isn't, the social media is a bad thing and we need to actually be doing something about it. Thank you very much.